Subcommittee number 1 of the Committee of General Laws and Technology. I would like to go ahead and call our meeting to order. And please call the roll.
Senator Parker?
Here.
Senator Black? Senator DeStefano?
Here.
Senator Servo?
Here.
Senator McPike?
Here.
Senator Vogel? Madam Chair?
Present.
You have a form?
Go ahead and get started. Person on assignment should be here, but
I'm ready. Madam Chair, members of the committee. Senate Bill 1128, basically adds to the Freedom of Information Act that provides that there shall be a rebuttable presumption that failure to respond to a request for records was willful and knowing. So basically, if a response or if a Freedom of Information Act request is not answered, then they have the opportunity to rebut that. But if they intentionally don't do it, it's willful and knowing, which gives it a little bit of teeth. The backstory on this was we have a few citizens who have requested information under the Freedom of Information Act, and we have a couple of bad actors who refuse to respond to a Freedom of Information Act request. And when they've pushed and pushed and pushed, nothing ever came of it. They just said, we're not responding.
questions?
So, what is a willful and knowing fine to get you sanctions under the mandamus action you bring?
I would have to ask Maria Everett on that. Is she still
Yeah,
here?
I'm still here.
Yep, here we go.
Madam Chairman, Maria Everett with the FOIA Council. Yes, the judge can impose monetary penalties for willful knowing up to $2,500 for the first violation and up to $5,000 for a subsequent. Yes.
Okay, thanks. Follow-up question. Is the concerns that you're worried about people are situations where people just don't respond at all, or where people provide partial responses that you don't believe is complete, or something different?
Or they intentionally don't respond.
Okay. Follow-up question. So are you, again, are you talking about where somebody sends a request and just absolutely nothing comes back, or where people send, I've seen people send requests with like 10 different requests, maybe they respond to one but not 9 through 10, or what?
And again, with the way this is structured, if they respond to 1 through 5, then they go back and say, hey, you didn't respond to 6 through 12, 10, then they have the opportunity to follow up and respond. This is where they willfully and knowingly don't respond, and they don't plan on responding, and they won't respond no matter what you say or do.
Follow-up question. Okay. I'm still not clear. First of all, I'm curious, is there a specific situation where this arose where somebody sent a request and nobody got a response of any kind at all?
And when the follow-up was done, they were told that they're not going to respond to the Freedom of Information Act request. And they were actually told that they don't feel that they should have to respond to a Freedom of Information Act request. And it's not just one. I've had probably a dozen of these in the last 2 years. I just decided it was time to do something about it because we're a transparent government. If somebody requests information on the Freedom of Information Act request, it stipulates what you can do, but there's no real teeth to the law. So if they don't respond and they say, I'm not going to respond, there's nothing really you can do. Take them to start court, but there's no penalty for saying, I'm not going to respond.
Of course.
Madam Chair.
I'm not sure if this, I'm not sure this person was you or somebody else.
I was not a party to this at all.
Okay, so did this person seek a mandamus action? You can bring it to General District or Circuit Court, either one. Did this person do a mandamus case, and then as part of that, had a problem showing it was willful and knowing to a court, or
No, I don't think they filed because when they did the research to file and hire an attorney, the attorney told them that, you know, they're not gonna get anywhere because they're not gonna respond. And there's no true way to make them respond.
Madam Chair, is this a, I mean, FOIA Commission's done a good bit of time in the last 3 years. Is this a follow-up request from the FOIA Commission in terms of providing enforceable action or a gap within the code?
Again, I would have to defer to,
Madam Chair, Senator Pike, Maria Everett, FOIA Council. We've just completed a 3-year study, enforcement provisions. We ran out of time, and that's the subject of next year's study, so this was not something specifically brought before the FOIA Council.
So, question, just doing something different. So there's a follow-up work plan that includes this provision at this point?
Right. Next year, we have, it's on our website, but one of the carryover study issues is enforcement provisions.
Anyone here to speak in support of Senate Bill 1120?
Madam Chair, members of the subcommittee, my name is Megan Ryan. I'm with the Coalition for Open Government. You asked for some examples, and we have had, I had 2 recently. One was for a school board in Central Virginia that just did not respond to a request, and so a citizen came to me and asked what they could do. In another case, another citizen who happened to be in my locality, James City County, had filed requests with DGIF that were ignored repeatedly, and actually it took the intervention of former Lieutenant Governor Bill Bolling to get them to finally respond to the citizens. So it does happen. So we're not really endorsing the, I mean, I would endorse sending it to the council for further study, but I do think it is an issue out there.
Question. So, when you say they didn't respond, I just want to make sure I'm clear about that. You're saying they got absolutely nothing back, or they got back a letter saying FOIA doesn't apply to us, or they got back a letter saying we're just not gonna respond because we need this exemption?
They didn't respond. She would, in the James City County, the DGIF one, which is the only one that I have repeated follow-ups with me with, the school district one just contacted me the first time, said they hadn't heard back. I don't know what happened after that. The DGIF, she would call, she would email, she would not get any response back at all.
Thank you. Anyone else in support? Anyone in opposition?
Madam Chair, Phyllis Arrigo with the Virginia Association of Counties, also speaking for the Virginia Municipal League today. And on behalf of the localities, we oppose this bill, and we oppose it for this reason. We've just started, after last year's bill, having records officers in the localities are going to be coordinating these responses. To us, this is presumed guilty before innocence, and there are a lot of situations where people send these in many different ways, whether it's email, text, phone call, that sort of thing, and sometimes the responses don't even get where they need to go. And to have the localities have to come in, or a records officer come into court and be presumed guilty when they haven't even had a chance to explain whether they got it or not, how it came to them, if at all, we really think is a problem, and for that reason we oppose this bill.
You said that you get requests by telephone. I wasn't aware that you could make a request by telephone or FOIA?
You can make a request any which way you want to. You can do it verbally, you can do it by phone, you can do it by any means, really.
Okay. Are you aware of any counties, for the question? Are you aware of any counties that have a practice of just not responding at all?
I am not aware of any counties, and in fact, in the years that I responded to these when I was in a locality, if I couldn't find anything or felt that there wasn't anything in response, we always sent a response saying, we do not have any records that are responsive to your request. So that's the best practice, and that's what we would advise localities to do, and I think that many do that.
First question. So if somebody made a mistake and got sort of sidetracked or lost or didn't get past the right person, and the county came to explain that, how do the counties think that wouldn't rebut the presumption this would create?
Well, it may rebut the presumption, but still, and I do see that as a point, but I said, but still, they go in being presumed guilty of something that they may not even know about. Thank you.
Anyone else in opposition?
Madam Chair, Mark Flynn, on behalf of Prince William County, and I will just give a personal example. Is when I was an attorney for a small agency, and the director of the agency was at a cocktail party and was asked for some records. You know, it was just a conversation, and he didn't even really realize it was a request. So he didn't provide the records because he thought it was just a cocktail party conversation. Next thing you know, we were in court. So that's the kind of thing.
Madam Chairman, just a question, is there not a requirement that the request be in writing?
No, sir. That's, it's a hallmark, it's a fundamental part of FOIA, that there's no, the General Assembly is wisely said that the citizen doesn't have to go through some formal process to obtain records. And the informality is what can lead to mistakes and decisions.
I guess I'm a federal guy, and I just know what's done there.
Okay, we'll let you have the final word.
Madam Chair, if I may, this doesn't truly address, well, it does address it with a rebuttal presumption, but this isn't getting at those who didn't see the email, misunderstood the telephone call, didn't read the text properly. This goes after those who willfully and knowingly say, I am not going to provide this information. We refuse to provide this information, period. And we'd like to believe that doesn't happen, but in fact it does. And I've been involved with having to make the call to tell somebody you really need to provide the information because under the Freedom of Information Act request, you're required to by law. And they said, we're not going to do it. They can sue us. That's not what transparent government is about. If they have a waiver for not providing the information, or if they don't have to provide it because of restrictions, absolutely fine. This is going after those who willfully and knowingly don't provide the information intentionally.
And I apologize for coming in late, we had a bus broken down on the road. But I'm just reading the summary, and it speaks of a presumption that that a failure to respond was willful and knowing, rebuttable presumption. So in saying that it only goes to willful knowing, doesn't this kind of force litigation over that issue? In other words, for the locality to deal with it, since it's a rebuttable presumption, then they're sort of under the gun to rebut that presumption. Or perhaps there are mechanics that I don't understand.
Madam Chair, if I may. I'd like to have Maria Everett come up and explain the mechanics of it. She's better at that than I am. But on something like this, the intent of this is if there's an email and they say, oh, I didn't see the email, great, no problem. Respond. And this is going after those who intentionally say, I am not going to provide the information, I am not going to respond, and I want you to know that we're not going to give you that information. No waiver, no nothing, they're just not going to do it. But Maria, if you can explain the mechanics.
Thank you, Madam Chair, members of the subcommittee, Maria Everett, with FOIA Council. The mechanics for enforcement of FOIA is filing a lawsuit, either in general district or circuit court. The burden of proof is on the government to show that they comply with the law, properly use an exemption. If you look at the bill, the sentence right before the new language says failure to respond is deemed a denial and therefore a violation. So the mechanics of it is if your rights under FOIA have been violated, you have a right to proceed to court, file an affidavit that alleges the manner in which your rights were violated. Then the burden, as I said, shifts to the government to show that they comply. So this, your only real remedy, other than, talking to the FOIA council and we working something out with people, is enforcing your rights in court. So you have to go to court, file a petition that says they failed to respond to my FOIA request. And the law is such that whether or not a mandamus or injunction is issued, the judge finds if the conduct was willfully and knowingly done, they can impose monetary penalties against that public official or public body.
Okay, the act on the motion, to recommend to, the full committee how to act on the Senate election.
Madam Chairman, speaking in favor of the bill. First of all, I think that FOIA is actually a lot easier to enforce than I think people might think it is. I mean, it is filing a lawsuit, but the reality is it's a one-page form you can pull down off the Supreme Court website, like a warrant debt. Fill in some blanks, you file it with district court. It's required to be given priority on the docket. I think they're required to hear it in court, I think within 10 days. 7 days. Okay. A real quick response period. You don't need a lawyer. Most people don't understand this. They get very overwhelmed and confused by it. But you don't have to file in circuit court a big long lawsuit. It's a very simple procedure. Number one. And two, the second thing I would say is that FOIA is supposed to err in favor of open government. And it's supposed to err in favor of production. And I think there's some responding entities, and not all responding entities are local governments. There are many other entities that FOIA applies to. And I think a lot of them don't take it as seriously as they should. And I have a bill coming up later which is similar to this, and I think that the system ought to be oriented in a way that encourages bodies to produce records and not hide them, and there ought to be actual real consequences for not fully producing. And right now there aren't enough consequences. Right now only consequences are the judge can impose a sanction after a trial and a hearing and you've shown willful and knowing failure to respond. And that just rarely happens. I've hardly ever heard about it happening. The fact that it doesn't happen makes me wonder whether the law is working. So, for those reasons, I think that this is a good way to start to retilt the playing field in favor of the public policy that's behind the statute to begin with. So I move to report it, or recommend reporting.
Let's wait for further discussion. Is there any further discussion?
Just add, I think approving those some recommendations earlier, I think this is a good section to look at. And I know the FOIA Commission is taking this on next year. And there's a couple of recommendations in that regard. I'm not sure how this adds value to the preceding sentence, which is pointed out in failure to respond to the request. The record shall be deemed a denial of the request and shall constitute a violation of this chapter. So I'd offer a substitute to recommend to send to the FOIA Commission for study this year, as there is currently in the work plan. Again, no demerit to the patron or the concept.
Secondary motion. So the secondary motion is to send to the FOIA council to study as in the work plan. Call roll on that motion.
Senator Barker,
Aye. By proxy.
Senator Black,
No.
Senator DeStep,
No.
Senator Servo,
No.
Senator McPike, Senator Vogel,
Vote, I'm sorry. On your motion, no.
Senator Locke.
Aye.
3 ayes, 4 nays.
So motion to flip the result.
So the recommendation be report.
Madam Chair, members of the committee, thank you very much. Yes, ma'am.
Madam Chair, I have two bills. One is,
I'm sorry, Senator Edwards, we will have to meet one additional time. Senator Edwards asked that his authority passed by because he has an additional vote to do on that bill. So if we have a motion to pass this by the passing Senate Bill 1226 by a vote, please say aye.
Aye.
Okay, so please.
Yes, ma'am. Senate Bill 931, this has to do with eliminating an exclusion from FOIA that currently applies to the working papers for college presidents. If you look at section 2.2-3705.7, it talks about chief executive officers who their working papers are excluded from FOIA. And it speaks to the governor, the lieutenant governor, the attorney general. The members of this body are with General Assembly, Division of Legislative Services, and the clerks. And that, I disagree with some of those exclusions, but by and large, it's consistent that we are making the laws and in an executive capacity, certainly the executive branch is in an executive capacity. Then we say, or the president or chief executive officer of any public institution of higher education in Virginia. Notice we don't treat any other agency head this way. We basically carve out college presidents among all state employees for an exclusion from FOIA. Everybody else, whether they're the head of Department of Corrections, or they're the head of Department of Education, or state police, or what have you, they are at least nominally subject to FOIA. Now, just because you're subject to FOIA doesn't mean you have to turn over your entire email list or anything else. I mean, we have 20 pages of exclusions to FOIA, and many of us who serve in local government are very familiar with some of those exclusions, personnel, financial records, things of that nature. But it's always seemed to be an anomaly that we have exempted college presidents, so my bill essentially strikes that exclusion. That's the sum and substance.
Any questions?
Question for Paige.
Yes, sir.
You said that department heads are not excluded. Aren't they included under the provision that their working papers are essentially a work product of the executive branch or the governor or whatever agency head?
I can just tell you that if you send an email to Maurice Jones or somebody like that who's a member of the governor's branch, it's subject to FOIA. I mean, I've had them FOIA, and state agencies are presumptively subject to FOIA.
Sure, correspondence could be something, Madam Chair, follow the question, but if it's specific to a development or policy proposal that's not yet public, it's still a working paper provision, is it not? I'm referring to sort of Maria as well.
Well, I mean, I'm just looking right at the code section. It speaks to governor, lieutenant governor, attorney general, members of the assembly, DLS, clerks, senate, or the mayor or chief executive officer. And I can just tell you from personal experience, I sent an email to Maurice Jones about the Redskins a couple of years ago, and it showed up in the Washington Post. And not because he voluntarily turned it over, they made a FOIA request.
Right.
So, again, I have no problem with that.
If it's simply a working paper, it's communication, would it not be, Madam
It
Chair?
would be correspondence.
Right, which would not be covered.
It says working papers and correspondence.
Okay.
Other questions? Are there those here who are in support of Senate Bill 931?
Madam Chair, members of the committee, Ashley Mason with the Virginia Press Association, we do support the bill for the same reasons that Senator said, discussed.
Okay, thank you. Those in opposition?
Morning, Madam Chair. Laura Fornash with the University of Virginia. Our presidents run, in many cases, multi-billion-dollar organizations, and the working papers exemption allows us to protect papers that may be drafts of items that the presidents may be considering, and this was something that the FOIA Council did discuss and decided not to recommend as part of their 2-year-long study. Just this year, we've responded to over 147 requests from FOIA, and only one of those we've actually used the working papers exemption. So we are responding to FOIA. The year of the Rolling Stone, we responded to over 200 requests as a result of it. So we are responding. It's just needing the protection of those documents that we use, that the president uses at her discretion for working papers. This doesn't protect anyone else at the institution.
Madam Chair, Elizabeth Kersey, Old Dominion University, for all of the examples that my counterpart at the University of Virginia cited, we also refers to this bill. Thank you.
Madam Chair, Matt Conrad, Virginia Commonwealth University. For those reasons, but during the summer, typically, we allow the work of the FOIA Commission to be a place where we meet with stakeholders, allow that body to consider thoughtfully the ramifications of legislation such as this, And usually there is compromise during those periods. The FOIA Commission did take up this bill, or one similar to it 2 years ago, and decided not to advance it. I would say also, as former counsel to the governor, there is an exemption that exists for the governor and all of his cabinet members. And that really is for the same reason that Laura sort of articulated, that at these executive levels, for instance, Virginia Commonwealth University is a highly complex $4 billion entity. And we need that space within which to deliberate and take risks.
Others in opposition?
Do I get the last word?
Of course you do.
Thank you. And I'll, and that's your lead, Madam Chair, and if these folks were in favor of it, I'd withdraw the bill, okay, because there'd be no need for it. But there is a need for it. We had a state university sitting on a $2.2 billion surplus, and we had no clue about that until someone that had served on the Board of Visitors actually let us know. We didn't know about that. So people talk about a multi-billion-dollar organization. I agree. That's why they need the scrutiny, okay? And if they weren't fighting against this bill, it wouldn't be worth having. I brought it because they are fighting against it. And we need to have more scrutiny over these universities. They have enormous amounts of money at their discretion, and they don't have the same scrutiny that political bodies have. The FOIA Council, God bless them, you know, we're here. And so I ask you to consider this.
I have a quick, maybe one of the universities can explain to me why it's important that the president be able to deliberate in secret. Anyone? I'm just not clear why secrecy is important to be able to deliberate over what to do with $4 billion of taxpayer money, or UVA $8 billion of taxpayer money, or whatever the budget is.
It's not deliberating in secret. It's a complex organization. We run a hospital. There are many proprietary things that the president has to review and get advice from her colleagues and her direct reports. And so it's really trying to protect that deliberative space. As I mentioned previously, it doesn't apply to any of our other administrative staff. It just applies to the president. Many complex decisions are made, hiring, firing, those kinds of things, new acquisitions, partnerships with companies, economic development initiatives. There's many things that could be harmed if information was made available in advance as that deliberative process is going on.
I have a question for Ms. Everett. Do the personnel exemptions and the proprietary exemptions and all that stuff still apply to universities?
Answer my question when appropriate, I'd like to read the report.
Just one comment. You know, when you discuss the magnitude of these institutions and the complexity, probably the best way for citizens to sort out those complexities is to go to the top of the pyramid. And the top of the pyramid is the president. And it just concerns me that we have that opaque situation with our universities, because there is such an enormous amount of money at stake. So I second the motion.
It's been moved and seconded.
Speaking of the motion real quick, Madam Chairman. Sorry.
It's been moved and seconded that Senate Bill 931 to be reported discussion.
Speaking of the motion, you know, I mean, I appreciate that people want to be able to deliberate in secret, but everybody would like to do that. The problem is, when you're dealing with taxpayer dollars, it's a completely different environment. And as to the FOIA Commission, you know, I appreciate the FOIA Commission is a useful place to vet things. I'm not sure if the FOIA Commission's approved a single proposal I made to them yet. I found the FOIA Commission to be heavily populated with stakeholders that, in a lot of ways, want to protect their stake. And for example, just this last year, the FOIA Commission reviewed, I think, over 200 different FOIA exemptions and didn't make a change to, I don't think, a single one. Maybe a change to 2 or 3, maybe. And so it does not seem to be an entity to me that is really it's definitely a place for compromise, but it doesn't seem to me to be a place that sort of is promoting more openness. It seems in a lot of ways to me to be sort of protecting the existing system. And so, I mean, I appreciate the FOIA Commission can vet things, but I don't take it as the definitive authority on what we ought to do with our taxpayer dollars or how much sunshine our taxpayers ought to have as to how their governments operate. So for that reason, I'm going to support the commission.
Madam Chair. Just a follow-up comment. I get the idea, and I'm in favor of increasing transparency. What concerns me is, say, the law firm of Isaac, Servo, and Peterson was to discuss distributions or other things, and you guys have conflict in working it out and sort of working the framework of partnership or other agreements. It's not that it's a secret thing, but it's a constructive dialogue in terms of where the organization is going. And so the end result should absolutely be public. It's sort of, how do you allow staff to be complete, so that means finished, or
Let him finish.
but the thing that concerns me in the end is how we allow those that serve the public also be creative and innovative in the designs, even though it might not be accepted, but allow to that dialogue to take place without feeling like it's frankly going to be put in a context that would make them be put in a negative light if it's rejected by the leadership or changed, or at least have a dialogue or discourse versus a bunch of yes people. I mean, you have to have that sort of push and pull. My fear would be that we would limit people's ability to have discourse within organizations for fear that they would cherry pick some parts of the information to put that out publicly when it's not the full context of the body of work and developing ideas. So I'm in favor of the idea, but it just cautions what sort of long-term impacts this would have to organizations' ability to have constructive dialogue and discourse. If it's financial information or other sources, which I think are absolutely should be on the table for all institutions, whether it be various sources, then let's drive at that from the fiduciary responsibility that we have as legislators. I absolutely think we should have that. To your point in this example, in terms of drawing out and making sure there's financial, as you say, in a certain circumstance, how information came to the legislators' knowledge, we should take a look at this and sort of caution on how deep within organizations that this would inhibit sort of the innovation and wanted to get patrons' thoughts on that.
Well, if I might respond, Madam Chair, or I won't.
At this point, we are preparing to vote on the motion. And irrespective of how we may feel about the FOIA Council, it is their responsibility to vet issues that are sent to them for discussion. And we can disagree with the outcome of what their recommendations may be, and that's fine. Let's just disagree with the recommendations. That doesn't mean we can criticize the council. Please call the roll.
Senator Barker?
No by proxy.
Senator Black?
Yes.
Senator DeStep?
Yes.
Senator Servo?
Yes.
Senator McPike?
No.
Senator Vogel?
Yes, by proxy.
Senator Locke?
No.
4 ayes, 3 nays.
Madam Chair. Yes, Madam Chair, the next bill is a little bit more esoteric. It has to do with foundations. And just by way of background, and by the way, this actually has a direct example from George Mason University, which is in my hometown, where we had a number of construction projects that were undertaken in the last 10 years that were done through foundations. For example, there was a hotel built called the Mason Inn that was built through a foundation. So it was essentially off the books of the university. And one of the things, and that, by the way, turned out financially to not be a good move, and since it was closed down. But increasingly, at least that university, and to my best of my knowledge, probably other universities, moved projects to foundations, so they had basically a semi-autonomous way to go ahead with developing projects and not have it be on the board of the university itself. Bless you. And so I had a suggestion, and by the way, this was suggested by, ironically, a professor at the School of Public Policy at George Mason, who said you really need to make foundations also subject to FOIA. again, as long as it's tied to a state university and its purpose is to support the university. Now, I will say a representative, and I can't remember if it was Mason Charter School, asked about donors to the foundations and whether the donor list would then be accessible to FOIA. I'd simply note, and I have previously, there's 20-some pages of exclusions. And I've actually looked through it, and I think the one that would be applicable would be 2.2-3705.6, subpart 13, trade secrets, confidential proprietary records. I know that any information that you keep secret, such as the identity of a donor and the amount donated, that doesn't need to be publicly disclosed, will be treated as a trade secret, and I think that's how probably our universities treat their current donor information. But I think that's a legitimate question, and I expect that to be brought up in opposition to this bill. I think the larger point is, and this to some extent dovetails with what I said previously, is that universities are multi-billion-dollar institutions, and an increasingly large part of their business they use through foundations, whether it's for building a stadium or building an apartment complex or building a public-private partnership. But again, they're state universities, they're utilizing tax money, they're utilizing our credit rating in some cases perhaps not. And I think presumptively, this information be subject to FOIA with all the protections that are already baked into the existing code. Thank you.
Thank you. Any questions? Mr. Irvin?
If I wanted to determine how a university is using its airplane through a foundation, could I do that today?
Most likely not, if it's owned by the foundation.
Further question? If I were to want to find out whether a university is using its foundation to give special benefits packages to its retiring officers after they retire in excess of their state employment benefits, how could I, through their foundation, how could I find that out?
Well, you couldn't use FOIA.
Further question? There's some schools that operate hotels and golf courses through their foundations. How could I find out how those types of things are being allowed to be used by donors or other third parties?
Well, that was precisely with George Mason and the Mason Inn. That was the example I used to get this off the books.
Any other questions?
Other questions? Are there individuals here in support of Senate Bill 1436?
Megan Ryan, Coalition for Open Government.
Others in support? Are there those in opposition to Senate Bill 1436?
Madam Chair, Matt Conrad with Virginia Commonwealth University. We are constantly encouraged by this body, its members, and the other body to act more like businesses, to innovate, to take risks. And we create entities such as our own investment management corporations to invest our funds so that as state revenue ebbs and flows, and the ability of the Commonwealth to support our institutions additionally ebbs and flows, we can smooth that revenue. Now, our investment management corporations exist as businesses. They contract with investment management companies whose information needs to be held confidential. And we actually will not be able to contract with some of those entities if this legislation moves forward. And then I would repeat our earlier refrain that, again, this legislation, the idea itself, has not gone before the council to be considered.
Warren Ashby, University of Virginia. We have 26 foundations, primarily those are fundraising foundations in support of the institution. I do have John Wynn with me today from UVMCO, who can talk a little bit and expand on Matt's comments in regards to the investment organization and how it does its work and why being subject to FOIA would be harmful to that entity.
Sure, I don't have anything prepared, but I'm happy to. I'm not a legislative person, but I can tell you that this would be very harmful. So UVMCO is the investment management organization for the endowment, and if something like this were to pass, it would be very negative on our ability to generate returns for the future of the endowment. What I can tell you is that we've had very good returns over the years, and a lot of that is due to investments that we're able to access that wouldn't be open to us if we were subject to full open records. This has happened in other states, and a lot of public institutions that were subject to these kinds of rules, they were excluded from some of these funds that produced outsized returns. In some cases, they went back to the legislature and got certain limited exemptions. I didn't see anything, again, I'm not a legislative person, but when I looked at the bill, I didn't see anything like some of the exemptions that are in other states or for VRS, such as investment deliberations or proprietary trade secrets of third-party investment managers. So, this would foreclose us from being able to invest in a lot of attractive investments. Furthermore, a lot of the investments that we have really punitive provisions that say if we were to become subject to this kind of rule, there are really sort of draconian remedies such as redeeming us from the investment at a low valuation, potentially haircutting the value by a significant percentage, and a lot of our managers that we invest with would be able to kind of withhold basically all information from us that would keep us from doing our job. I can sort of go on and on. What I can tell you is that it's not just sort of a nuisance. I mean, there's nothing that we're doing that we worry about. It's like a nuisance. It's just it would be real significant economic cost to the future returns of the endowment.
Any question for Uvemco? Sorry, what was your name again?
John Wynn.
Mr. Wynn, is Uvemco's ability to make investment decisions, is that the only concern you have about this provision as Uvemco?
Well, I'm just here from Uvemco, so
Right,
I mean, that's all I can really talk about. I can let Laura talk about the
Okay.
foundations. But
Further question? I understand UVA has a lot of other issues with this idea. I'm talking about Uvemco.
Right.
If Uvemco had an exemption that was similar to what VRS has in terms of making its investment decisions, would that satisfy your concerns?
I don't think it would fully, because so my job is to negotiate the investment contracts we have with our managers, and they're written, because of some of the situations, they're written so strenuously that if an investor is subject to any kind of open records law, they basically just say, we can take all of these remedies, because the best investment managers, they can pick who they want to invest in their funds, and so they don't have to deal with something the way they want to deal with. And so, even the VRS exemption says they've got to disclose all the names of their managers, their present value, and so I can think of a number of our managers that would just say, sorry, and whether they would kick us out on these punitive, I was looking at one investment the other day that said if you become subject to FOIA, we can remove you from the fund for the amount of your capital account, which would be a low valuation, and we can take 50% of it. So, I mean, we're talking about lots and lots of money from the endowment that's just left on the table.
But we also have the University Physicians Group, which manages our doctors at the hospital, and that would be another entity that would be now subject to FOIA. They negotiate many contracts, they pay employees, and so I think there's just so many implications of this legislation. It dropped on Friday. We're just trying to understand the implications. We really think it would be better to have it run through the FOIA Council and it could be fully vetted during the off-season.
I have a question from this point. The entity you just described, you called the university what?
Physicians Group?
That's a 501c3?
It is.
Why is it a 501c3?
I don't know the history on it. That's just the way it's been set up over the years. Doctors and many of our physicians are
Further question?
members of this.
What does it do that's charitable? I don't understand how it could be a charity if it's employing doctors.
I don't have the full history on this. Again, the bill just dropped, and we're just trying to understand all the implications for the different foundations of the institution. So we'd ask for more time.
Elizabeth Kersey, Old Dominion University. In addition to the comments from my colleagues, we do have a lot of concern that this bill could significantly impact our ability to raise funds, because we are worried that it would make a donor information foiable, which could have a real chilling effect on our donors.
Others? Senate Bill 1436.
Madam Chair, relative to the last comment, it's your understanding that this would make your donor list subject to?
That's the interpretation of our council, yes.
I can respond to that. There's an existing exemption under 2.2-3705.4 subpart 7, which says information maintained in connection with fundraising activities by or for a public institution of higher education that would reveal fundraising strategies, wealth assessments, estate. It goes on for about a paragraph. That's the existing exemption. That would still be in place. So that's already covered. Madam Chair, I'm happy to sit down with colleges, and I agree, this just dropped, and there are implications here. And I'm not trying to rush this past anybody. The president wanted to have it for a couple of years, so that's nobody's surprise. But I'm happy if you all are going to meet again.
We're going to meet again.
I'm happy to meet with folks, and I'll walk through all these exemptions and see what's a problem, what's not, Madam Chair, if you want me to come back.
Okay, we can take this back, but, because we're gonna meet again.
Happy to do that.
I make that motion.
Okay, all in favor of passing this back, I believe, please say aye.
Aye.
Thank you, Senator. Okay, we'll take up Senator Henry's bill, Senate Bill 1040.
Thank you, Madam Chair. I was contacted by Senator Hayner's aide, and what he would like to do is make 2 amendments to it that would conform it to a FOIA bill that is coming from the council. What the amendment would do is on page 2, line 64, the speaking language that used for the purpose of receiving electronic mail from the public body would be unrestricted. And also on line 65, actually, that be you would reinsert the speaking language electronic mail recipient, and after that line you would strike person providing such information. What it would basically do is confine it to email address information, and it would put it in line with the bill that's coming from the FOIA council that we haven't seen yet. We don't talk about bills about the house, but that was his wish to conform to that bill.
Any questions on Senate Bill 1040?
What's the issue that this is resolving?
Speaking for Senator Hayner, what it would have done, it would have been a broader exemption, exempting any information that the public official had about the personal contact information. What the amendments would do would make it specific to email, electronic mail address information. Senator Hayner indicated to me that he wanted to, he didn't want to be that broad, that's when he tried to work something out. Speak for him, but he didn't make it like that. Would make it less controversial.
Is there anyone here in opposition to Senate Bill 1040?
Megan Ryan, Coalition for Open Government. We did speak with Senator Hayner about his, the concerns that he had, and the actions that he's taken to resolve those problems. Thank you.
You're saying they were resolved?
Yes.
Okay, so we need a motion on Senate Bill 1040.
Move to report.
Second.
Moved and reported, moved and seconded that we recommend reporting Senate Bill 1040. All in favor? Please say aye.
Aye.
Thank you. Senator Searle.
Can we do 1102 first?
Senate Bill 1102.
Okay, Senate Bill 1102 was a bill that I introduced last year. It was referred to the FOIA Commission and vetted by them, did not receive a favorable recommendation. Just to give you all an understanding where this camp comes from. This has to do with allowing families whose family members either unfortunately commit suicide or are found in situations where they passed away from the physician, allowing them to obtain records and closure in terms of what happened to their loved one. Currently, the code gives law enforcement 100% discretion as to whether or not to provide these records or not, and there's inconsistent practice across the Commonwealth about that. Some police departments are very forthcoming, others, and sheriffs, and others are not. When it really came to my attention, it's actually come to my attention in my law practice sometimes, we'll talk about in a second, when it really came to my attention was in a situation in Virginia Beach where a was a military, he was in the Navy, committed suicide, and his family attempted to obtain records surrounding the investigation of his death, because they wanted to have an outside expert review it, the police department, and look at to determine whether or not they felt the police had reached the right conclusion in the case.
Madam Chair, if I may, whenever Senator Servo comes to Virginia Beach, we send them back north as quick as possible. I just want to make that for the record.
Good thing.
Yeah, might get a noise violation or something. In that case, the family filed a suit. The circuit court judge refused to release the record. The Supreme Court refused to hear the case, and the family still has not received records as to why they're looking into the circumstances surrounding their son's death. I think Delegate Bill Nueva put in a last year about it too, I think, which the House did not act in favor of, which Senator Norman says I'm not supposed to talk about. In any event, so in addition to that, I've had it come up in a couple of situations in my own law practice. For example, I had a situation where a gentleman was found dead in a bathtub. He had terminal cancer and was on lots of heavy painkillers, and there was an issue as to whether or not he had committed suicide or whether or not he had an accidental death. The life insurance company did not want to pay because they felt like it was a suicide. And we had to try to obtain records. And ultimately, after a bunch of consternation, we were able to get the law enforcement agency to provide us with what after. I also had a case where somebody died in Las Vegas recently. Turns out in Las Vegas, next of kin is allowed to get the report. But in Virginia, that's not the law, and so you can't get that. And so basically what I tried to craft in my statute is a provision that says that next of kin, if the family's been ruled out as suspects, it's an unintended death, the family's been ruled out as suspects, they don't think it's a criminal case, the case is closed, then the next of kin can obtain these records. Next of kin is to determine the order of intestate succession, which is how we do it for both trust estates, and your current family or household member is defined as it is in Title 16.1 of the code, which is how we use for juvenile court. But basically, this just allows families to obtain closure when they need it. And I don't know if you all saw this editorial or not, it's been favorably editorialized by the Daily Press, who expressed consternation that my bill was not favorably acted on at the FOIA Council. But from my point of view, it's a common sense measure to help families obtain closure. What you're going to hear in response is concerns from law enforcement that this may allow some conniving family member who killed their spouse or loved one and wasn't discovered to obtain records and ultimately avoid prosecution on that way down the road. I think that's so unlikely and improbable that it really shouldn't prohibit everybody else from being able to get these records. The second thing you're going to hear is concern, I think, from law enforcement about their abilities to try and go after narcotic suppliers in unintended death situations. Sometimes when somebody dies of an overdose, they want to be able to go after the people who supplied the records, and they don't want to have to get into producing that kind of stuff. And I think they just emailed me some language which I think might help solve that problem, which I'm open to. But I just got the language about 10 minutes ago. So, anyways, that's the bill. I'm happy to take any questions about it. Oh, I'm sorry. One other article I want to get really quick. The Supreme Court in 2015 also made a decision. There was a family in Loudoun that tried to get a suicide note. There was a lieutenant who killed himself, and he left a suicide note for his boss. And the Loudoun Sheriff's Office gave his family everything except the suicide note. And they just wouldn't turn over the suicide note. The family wanted to see it, and they just wouldn't give it up. And the Supreme Court of Virginia held that was entirely within their discretion, was to refuse to turn over the suicide note. Gave everything else but the suicide note. So, I mean, it's that kind of stuff that's going on, which to me is just inappropriate. I think it all should be subject to this law.
Any questions? Anyone here in support of Senate Bill 1102?
Megan Ryan, Coalition for Open Government, and I just wanted to, in full disclosure, that as an organization, we signed on to a friendly court brief in the Virginia Beach case that did ask for the court to say that they did not have blanket discretion to make that decision.
Ashley Mixon, Virginia Press Association, we're also supporting it.
Anyone here in opposition to Senate Bill 1102?
have a problem with the goal of the bill. We're just worried about the language, because we can see the problems that will arise if there's an unintended death, say a drug overdose, the sheriff's department says, we completed the investigation, we don't know where the drugs have come from. We have to turn over our file at that point to a family member and lose control of the investigation, which could still result in criminal charges down the road. We suggested language that would limit this to when once a determination has been made that there are no criminal charges to be filed. And I think that would take a lot of our interest out. But I think that you need to know as well that in our files, and this would require us to turn over our files, there's lots of sometimes sensitive information about informants that should probably not be turned over. There's also things that are criminal to turn over, like medical records, criminal investigation records, that kind of thing. So when you talk about turning over the whole file, it has implications. I think we can work on the bill, because I don't think we have a problem with what we're trying to do here, just the wording that takes in areas that we don't want to go to. I think the senator agrees with that.
I agree with that objective, and I'm looking at the language after I've interlineated it here. And I have no problem with the proposed amendment, which I can read to you all from now.
All ears.
Okay, if you have the text of the bill in front of you, on line 35, after records of completed unattended death investigations, you would add where determination has been made that no criminal charges will be pursued. And then strike, line 36, comma, provided through the end of the line. I think that would also mean to strike the rest of it. Of the amendment, of the proposed change. The determination of no criminal charges will be pursued. Provided, I think the rest of this will come out in terms of weight and stuff that's in the Senate.
Okay, read that for us.
So we basically say going forward, records of completed unattended death investigations where determination has been made that no criminal charges will be pursued. To the most immediate family member of the victim. Well, you know what? We need to. That's what we said. Okay. That's what we said.
Could you do that?
Yes, and I appreciate that amendment. One thing I would, as we sat here, we realized that we can't really turn over criminal records, cell phone records, things like that. I know you hate the word redact, but we probably need to have the ability, if we're going to turn over our file, to take out things that should not be disseminated publicly.
Motion to accept the amendment.
Ms. Moon seconded that we accept that amendment. All those in favor, please say aye.
Aye.
Now we need a motion on the Senate Bill 1102 as amended.
Move to the board. As amended.
Mr. Chairman, I worry a little bit that there was commentary about protecting sources, and I'm not sure, do the gentlemen feel that this change is going to be sufficient to protect confidential?
I don't know who this gentleman is right here, but he says that we could add some language that would just say.
Let this gentleman talk, he knows more than I do.
But that would include other provisions in FOIA that would protect us from having to do that. That just Alan Gertner with the FOIA Council, Madam Chair. Basically, just generally the way FOIA works, if an exemption applies, it would mean redacting whatever that exemption covers. And there are a number of exemptions here that cover other things, such as criminal investigative files. This, as amended, if I'm reading it correctly, would be an affirmative release requirement solely for records of the completed unattended death investigations as amended. Other records which are subject to other exemptions could still be withheld. That's just the way, that's the way Florida works now. So if something else, for example, there's a prohibition on the release of a criminal informant's identity, that would still apply. Other exemptions that protect victim and witness identity would still apply, etc. And they are numerous.
Follow-up question, Mr. Chairman. I know it's somewhat out of order, but I appreciate the discretion. The family member notification, in this case, would still provide the next of kin relationship. What occurs in a situation where you have a parent that wants information, but it's not getting that as well? They wouldn't be allowed access under this provision, is that correct? So a parent or child, but they're married and said next of kin is their husband and spouse, whatever relationship.
Under this provision, under this statute, if the person was married and the spouse survived, the parents would not be able to obtain the records, only the wife could. And I did that deliberately, because I know these family situations are complicated, and I was not looking to create a situation where all the way down from cousins and everybody else could be asking for this stuff.
The complicating factor being in the case where the spouse is a member of the investigating agency. Just for a circumstance where literally the spouse is a member of the investigating agency who's making a determination as well, which is conceivable. And the parents want to get additional information about that. So we can address this another day. I don't think it's the part of the bill, but.
Madam Chairman, have you considered the situation? I think often when you do this, probably someone is wondering whether there was something amiss, that, that there was foul play, and that it just was not picked up by the authorities. And where you have a husband-wife situation, I think it would seem like that would be one of the most common situations where perhaps the parents would be wondering, okay, was this a suicide, or was this something caused by the spouse? And I'm just wondering whether you had given consideration, maybe to saying that the next of kin would include both the parents and the spouse, and the surviving spouse.
I hadn't thought about it specifically, but I think that's a policy judgment the committee wants to make. I'm not sitting here right now necessarily opposed to it, but
I'd recommend it. I don't see harm to this with the bill.
I'm sure Nico could craft something to say that the most immediate family member to include the person's parents
And the spouse.
if any.
And I would move that amendment concept.
Just to be clear, as I understood it, we were going to keep the language for purposes, are you taking that language out now, where we define immediate family, that's gonna stay in?
Sometimes there might not be children or spouses, there might only be nephews or nieces or other. That was actually the city.
What's being added?
Yeah.
What's being added is that, as I understand you would, if there's a spouse, then there would not be, parents would not be considered the next of kin.
Current law.
Under the current law.
Proposal.
So the amendment would be that the next of kin would include both the spouse and.
As I'm seeing it, we're saying parents or spouse as a group, or immediate family.
Yes.
Okay, so
Yeah.
we're talking about these don't exist, then you go to the immediate family.
Yeah.
Okay.
Yeah.
I understand.
So is that an amendment?
If we could, I would move that as an amendment in concept.
Second.
Moving second that recommended that SB 1102 be recommended for reporting as amended. All in favor, please say aye.
Aye.
And then, Sir, John?
Okay, Senate Bill 1103, another bill was heard by the FOIA Council and close to being recommended. I think it was a tie vote at the end of the day. But 1103 is a bill designed to create more incentive for responding entities to be active about their closed meetings. So, just so you aren't, I'm not sure everybody here is familiar with how a closed meeting works. I know Senator McPike is because he's probably been in one, and Senator Steph has, probably hundreds. But actually Senator Locke has too, I'm sure. So, probably me and Senator Black has never been in a closed meeting. Okay, you've been in some too. Okay. Maybe I'm the only one. In any event, you have to announce at the beginning of the meeting what you're going to talk about, and when you come out of it, you have to certify that you only talked about what you said you're going to talk about. And I'm concerned about whether or not the closed meeting process is being abused and whether or not there's appropriate consequences for people that abuse the process. And there's two examples that will give me heartburn, and then a bunch of rumors I've heard, which I'm not going to get into. But let me say that in Prince William County, about 3 years ago, the Board of Supervisors announced they wanted to talk about a pay increase for themselves. And they decided they wanted to do that in closed meetings because that was a personnel matter. And they went into closed meeting and then rapidly came out after one of the members expressed a violent objection and said he refused to participate in such a thing. And so they decided not to do it. But I thought that that was a pretty clear wrong interpretation of the code. But it was, to me, just the idea that you would even use the closed session for that was pretty unusual. Secondly, I assume everybody's familiar with the situation about what's going on at the University of Virginia. I brought an article where Ms. Everett, who's not here right now, but on behalf of the council, rendered an opinion that what occurred at the University of Virginia might have been a violation of their the closed meeting provision. Before they went in to discuss their strategic reserve, I think they told the public they were going to discuss personnel matters, budget matters, and maybe, where is it? It says here somewhere what they talked about. Yeah, whatever it was, they didn't give the notice to the public at all. They were talking about the creation of a $2.1 billion special fund. And right now, if the closed meeting violation provision is violated, I'm not clear there's any consequence for it. There might be a consequence, I guess, for maybe willful and knowing violation, maybe, but.
Madam Chair, I'm here for FOIA Council. Again, the basic procedure in FOIA is a petition for mandamus or conjunction where the court would order whatever remedy the court feels is appropriate to the situation. In addition, there is a provision for knowing willful violations where someone will have to pay the monetary civil penalty to the state literary fund, and it comes out of their own pocket. And of course, that requires that the court actually find that they knowingly and willfully violated the act.
And so, what this does, this creates more of a strict liability situation where if any person improperly votes to certify a meeting, then, and the court finds that they improperly voted to certify a meeting, then they're subject to civil sanction of $500 we pay to the literary fund. And from my perspective, what this will do is sort of reorient people around ensuring that, A, the public is given proper notice of what's going to be talked about, and B, once those meetings start, that they not stray from what they're supposed to be talking about into other matters. I think it would also help counsel err on the side of openness instead of closeness, because right now I just don't think there's enough consequences, and so that's basically what this does. And again, we had a tie vote on the FOIA Commission, which is about as close as I've gotten to getting something out, but some of the local government people thought it was, can I read that? Some of the local government people thought that that it was too punitive and harsh to hold people accountable without a knowing and willful component to the statute. I'm happy to answer any questions.
Questions? Okay, are there those in support of Senate Bill 1103? Those in opposition to Senate Bill 1103?
Madam Chair, Phyllis Rico, on behalf of the Virginia Association of Counties, also speaking for the Virginia Municipal League today. We're opposed to this bill. We think that the remedies are adequate, and this strict liability or mandatory language really doesn't give the court any leeway at all to look into the circumstances. And again, based on my personal experience in the localities and in closed meetings, deviations can be very inadvertent and insubstantial. And I will give you an example that I've been in one. Public body's in a closed meeting and somebody says, by the way, did you know so-and-so was in the hospital, he just had a heart attack. One of their colleagues or associates or employees. And was that notice to go in under? No, and under this, that kind of thing, that kind of inadvertent, non-substantial would be brought in and would be subject to the penalty for all the members. So we oppose this.
Others in opposition to Senate Bill 1103?
Is it your report?
Second.
It's your report.
It's been moved and seconded that Senate Bill 1103 be recommended for reporting.
Just one comment. This, I think this is important. I think there's a higher standard in public meetings and closed sessions, and I think that needs to be emphasized in this sort of framework to get the attention of folks to make sure that they don't get off the track of what is publicly noticed. And this, I think, is important that we emphasize this and send this message.
I'm a little uneasy with the idea that it doesn't have to be knowing and willful. And I think the example was an awfully good one where I really would like to get it at what you're trying to get at, but also as a practical matter, these things are not done in a real rigid fashion. Once you go into closed session, there tends to be, people are human and they tend to sometimes stray a little bit. It's one thing if they're going clearly off track and they're talking about a major policy issue, but this is such a severe approach to it. I wish there was some way we could tailor it a little bit more to what you're trying to get at. So just a little bit uneasy with it for that reason.
I am as well, Scott. I mean, I go into a lot of closed session meetings still. Being on the Fort Monroe Authority, we do a lot of closed session meetings. And there hasn't been a time when what's on the agenda for closed session has gone awry. But I think the civil penalty issue is what kind of is Senator Barker's concern. So, just a little bit uneasy with the willful part of it as well. Because I don't think there may be some instances where it may be willful or intentional, but I don't think that people intentionally go off the deep end in closed session meetings. And there's never been a situation where I've been in a closed session meeting where it's been intentional to just kind of go off the deep end in a closed session meeting. So, I'm sorry.
I'm sure I've been in a lot of them, and I've been where they have intentionally gone awry, and I've tried to pull them back, and I've actually walked out of 2 closed session meetings because they went on something that wasn't on the agenda, and it was something that should not be discussed there. And I literally walked out of the meeting, went back when they went to certify and said, I refuse to certify because you didn't follow the rules of what we're doing. So what they did was open the door, had the conversation, then close back to get back to the agenda. There are not a lot of people with the testicular veracity to do that, and that's one of the problems we have. And not only is it done once, it was done here, I've seen it multiple times, and when I served on the CIPSA board, it used to happen just continuously. They used to actually have illegal closed-door meetings with 4 or 5 members without inviting any other members in there, and that violated the 3-member rule. They had closed sessions without, it was a mess. John Cosgrove, Senator Cosgrove, when he was Delegate Cosgrove, actually put in a bill to control all of that, and it does happen, it continues to happen, and a lot of people just go along with it, and they don't quite understand the FOIA, they don't quite understand the law as it relates to that. So it does happen, and it happens frequently. When you have a strong leader who runs the agenda and tends to vary from, take a different path from that agenda, they actually can do this frequently. And folks will just certify because, at the end of the meeting, you just certify. They don't even quite understand why they're certifying or what they're certifying. And in the case of this one, that was the case because I talked to every member of the board that was sitting in that room that day. Everyone told me exactly what was discussed, with the exception of 2, and every single one of them did not know when they were certifying that they were truly certifying what they discussed was within the agenda. So, this is part of it. The other part of it is an education standpoint. From an education standpoint, people need to be better educated.
And Trace, can I have the last word there? Yeah, I'm on the committee, right? I just note that, consistent with Senator Steph just said, I believe there was somebody on the FOIA commission, I don't remember his name, but who voiced similar concerns. I think he said he had previously served on the town council somewhere in Southside. And he said that he found that they would often, he said often, but he said that he would find that they would go astray, and that he thought that the incentives would be put in the right place to try and incentivize people not to go astray. And that was one of the reasons he said strongly supported this idea.
Chairman, not to prolong this, and I'm very sensitive to what you're saying, but aren't you giving examples of knowing and willful transgressions? The ones you're talking about, those were knowing and willful, weren't they?
Correct. Every one of them, the person that was running the meeting knew what they were doing. And on more than half of them, the attorney that was present tried to guide it back, but was either pushed back by the person leading that closed session, which is why I left 2 of the meetings, or when the city attorney at the time tried to pull it in, folks just quickly shut up and got back onto the agenda. So, but it does happen a lot.
I just wonder whether maybe
at times it is willing.
Maybe the problem is the penalty is too low for a willing and knowing violation.
I think is willful and knowing is covered in the first chapter, correct? The paragraph above, that goes up to $2,000, I believe. I think that's 500 to 2,000 if I'm not mistaken. I read this a couple months ago.
Senator Barker?
No by proxy.
Senator Black?
No.
Senator G-Step?
Yes.
Senator Servo?
Yes.
Senator McPike?
Yes.
Senator Vogel?
No by proxy.
Senator Locke?
No.
3 ayes, 4 nays.
It's just a recommendation.
This is just a recommendation.
Yeah.
So we'll have one more meeting, and we don't know how many more goals we drop by Friday, so we'll have one more meeting next